Welcome to this week's Legal Insight with Ungada Attorneys. Today, we're exploring an important topic in South African succession law, the Pactum Successorium, or succession by contract. This is an agreement that tries to control how a person's estate or certain assets will be passed on after death. However, South African law generally declares such agreements invalid because they conflict with the principle of freedom of testation, which allows a person to change their will at any time before they die. The problem is that contracts are usually bilateral and binding, while wills are revocable. Courts, following Roman Dutch law, prohibit pacta successoria to prevent two main issues: restricting testamentary freedom and bypassing the formalities required by the Wills Act 7 of 1953, which safeguards against fraud. To decide if an agreement is a prohibited pactum successorium, courts apply a two-part test. Do the rights vest only upon death, and is the agreement irrevocable? If both answers are yes, the agreement is likely invalid, as confirmed in Borman and de Vos NNO v. Potgieters-Russa Tabakkorporatie. But there are exceptions, most notably the donatio mortis causa, a gift made in anticipation of death that complies with will formalities, and succession clauses in antenuptial contracts, which are binding between spouses, as affirmed in Joubert versus Joubert. These exceptions show how South African law balances contractual arrangements with protecting testamentary freedom. In summary, pacta successoria are generally prohibited because they undermine the right to freely change one's will and avoid the formal safeguards against fraud. Yet, limited exceptions like donations mortis causa and antenuptial contract clauses are recognized, allowing some contractual succession arrangements that do not conflict with core principles of testamentary freedom. For legal advice or assistance with estate planning, contact us using the details below. Thank you for watching Legal Insight with Ungada Attorneys.